Please remember to leave a like, a comment, share the video about, and if you haven't already, subscribe. Thank you. Well, isn't this just fantastic? I know I don't usually upload on a Saturday, but Madcatster very kindly emailed me some legal documents, heavily redacted, but that's for the right reasons, concerning Illuminaughti, Ozmedia, and one other called Felix the KitKat. Yes, 2 separate PDFs, and I thought, let's go through those, because apparently things have swung a little in Illuminaughti's favour. Both Ozmedia and Felix the KitKat have filed a motion to dismiss, and highlighted in green are the parts that we need to pay attention to. Before the court is the motion filed by defendant Ozmedia, seeking dismissal pursuant to, and then that, and Colorado's Anti-SLAPP statute of plaintiff's claims against him in the second amended complaint. Those complaints were amended a number of times, and there were other ones I think almost came close to being thrown out because of it. I have previously allowed 2 amendments of the complaint, following which Blank renewed his motion to dismiss Ozmedia. I have reviewed the renewed motion, the response and the reply along with the case file and applicable law. Applicable standard on 12b-5 motion to dismiss. When considering a motion to dismiss for failure to state a claim, Colorado courts until recently applied the no set of facts standard, dismissing a complaint only if it appeared beyond a doubt that the plaintiff could prove no set of facts that would entitle him or her to relief. In 2016, the Colorado Supreme Court modified that standard by adding the requirement that the complaint state a plausible claim for relief. Under the Warner 1 standard, the trial court still accepts all allegations in the complaint as true and views them in the light most favourable to the plaintiff. However, facts pleaded as legal conclusions are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. Quote, simply asserting a legal conclusion bereft of any supporting factual allegations does not state a plausible claim for relief. A motion to dismiss for failure to state a claim is a challenge to the facial sufficiency of the complaint. It is directed at the 4 corners of the complaint, and accordingly a court generally may consider only those matters stated in the complaint. However, Rule 12b provides that if additional matters outside the complaint are presented, the court has discretion to take those matters into consideration and convert the motion to a motion for summary judgment, after giving all parties a reasonable opportunity to present material that would be relevant on a summary judgment motion. I elect not to do so, as the motion has not been fully briefed in that posture. If matters outside of the complaint are submitted to the court but not considered, it is within the court's discretion whether or not to convert the motion to dismiss into one for summary judgment. Standard on Anti-SLAPP motion. In 2019, the General Assembly enacted the Anti-SLAPP statute to address lawsuits aiming at stifling or punishing the right to free speech, commonly known as strategic lawsuits against public participation, SLAPP, and to provide a procedural mechanism for the early consideration and dismissal of such lawsuits. Colorado's anti-SLAPP statute is directly modeled after California's statute, and also codifies pre-existing Colorado case law. The anti-SLAPP statute provides in pertinent part as follows. A cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the United States Constitution, or the state constitution in connection with a public issue, is subject to a special motion to dismiss unless the court determines that the plaintiff has established that there is a reasonable likelihood that the plaintiff will prevail on the claim. Colorado follows California's 2-step process for considering the special motion to dismiss under the anti-SLAPP statute, and Colorado's courts look to California cases for guidance on how to apply the statute. I don't want to be that guy, but following California is an interesting one. Although, the idea of anti-SLAPP is good. Yeah, I like it. Because lawsuits aimed at preventing another from speaking? Yeah, no, I don't like that. And that certainly does seem to apply in this case, where Illuminaughti has used NDAs to prevent others from being able to speak, which I think is vitally important. First, the court determines whether the defendant has made a threshold showing that the conduct underlying the plaintiff's claim falls within the scope of the anti-SLAPP statute. that is, that the claim arises from an act in furtherance of the defendant's right of petition or free speech in connection with a public issue. An act in furtherance of a person's right to petition or free speech in connection with a public issue is defined to include 4 specific types of acts, of which the third is relevant here, the third being any written or oral statement or writing made in a place open to the public, or a public forum in connection with an issue of public interest. If the trial court finds that the claim falls within the statute's scope, then it proceeds to the second step. It reviews the pleadings and affidavits and determines whether the plaintiff has established a reasonable likelihood of prevailing on the claim. I look forward to seeing how that works out. If the court determines there is not a reasonable likelihood that the plaintiff will prevail on the claim, the court must grant the special anti-SLAPP motion to dismiss and award the defendant their attorney fees and costs. Something which I hope happens, to be honest. It is quite well known at this point I'm not the biggest fan of Illuminaughti, not least for this lawsuit. And yes, I said lawsuit, not lawsuit. Breach of contract. The first claim for relief for breach of contract alleges that Oz Media entered into an agreement with Blair that required that he not use confidential information and or proprietary data for the benefit of any other person, corporation or entity other than the employer during the employee's employment with the employer, that's a lot of employee, or any time thereafter, and that he breached the agreement by using confidential or proprietary information to defame or otherwise harm plaintiffs, which has been proven demonstrably false. She harmed herself when she went for legal. That was the straw that broke the camel's back and got many more people digging into the crap she's been producing. She has for years been skirting, and now her channel is on life support, with the plug pulled. Examples of these breaches are set out in paragraphs 41 and 46 of the complaint. We have been through that in this video sort of series, I guess, at this point. There are also reference paragraphs 58, 59, 63 and 64, but these paragraphs refer to alleged breaches by other defendants. Wonder, Felix, so on. Oz Media contends the breach of contract claim against him should be dismissed pursuant to law because it fails to set out with particularity his statements or other conduct that allegedly breached the agreement. The anti-SLAPP statute is not implicated by this claim. Paragraph 41 alleges that in April of 2023, Oz Media published a series of Twitter, now X, posts naming Blair as the aggressor and falsely claiming she has a habit of starting fights. These posts also include Blair's confidential information. A link to a Twitter address follows, but clicking on the link does not produce the alleged posts. Paragraph 46 alleges that in September 2023, Oz Media released a video titled Let's Talk, an update on Illuminaughti drama, which continued accusations in which Oz falsely accused Blair of embezzlement. Nothing in either paragraph sets out the specifics as to how Oz Media used confidential or proprietary information to defame or otherwise harm plaintiffs. Now, there is always a distinct chance that in the videos he produced, there was a minor slip or two. And of course, we must respect the process of this as it unfolds with time. Errors are going to happen on both sides. It's what we saw with Blair when she constantly changed her claims. Although that could also be because she was desperate. Earlier in the paragraph, it mentions falsely claiming she has a habit of starting fights. The thing here is, she actually does. Her own Twitter history is against her on that. Or X history. I mentioned Legal Eagle. Legal Eagle laid the smackdown with like one polite response. But she tried to start something with Legal Eagle. It was incredibly cringe. The court notes that in its order of the 15th, oh god, you do it by month, day, year, don't you? 15th of January 2024, my birthday. Authorizing a second amended complaint, the court instructed Blair that all statements on which they relied shall be set out verbatim in the complaint. That order was necessary because Blair, in their previous iterations of their complaint, had failed to specifically set out the statements by Oz and others that they alleged were defamatory, making a substantive review of the complaint impossible. Yes, it was all very nebulous. Plaintiffs have again failed to comply. A link to what purports to be a Twitter thread is not the same as verbatim representation of the specific statements to which plaintiffs object. It leaves the parties in the court guessing, and accordingly it violates the court's very direct and specific order. Finally, identifying the statements in their motion response is inadequate. The statements must be set out in the complaint. Shocker, Blair didn't get it right. repeatedly. As noted above, under the Warner Standard, boilerplate or conclusory allegations are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. No such specific factual allegations support this claim, and accordingly it is dismissed. Oz Media contends the remaining claims against him, the third and fourth causes of action for defamation, should be dismissed pursuant to the Anti-SLAPP statute, or in the alternative, pursuant to Rule 12b-5. The statements identified in Claim 3 made in a YouTube video by Oz Media after the case was filed accuse Blair of embezzlement. The statements identified in Claim 4 made by Oz in the same video accuse her of having placed him in a dependent, arguably coercive financial relationship with her. A. Anti-SLAPP statute. I find the Anti-SLAPP statute does not apply because Oz cannot satisfy the threshold part of the analysis. While the parties agree that Oz's statements were made in a public forum, they were not made in connection with an issue of public interest. Neither of the statements identified in Claims 3 or 4 were made in connection with an issue of public interest. While they were made in the public forum of the internet, and while Blair may or not or may be a public figure, they arise out of a private dispute between both, and they solely address that private dispute as opposed to larger, more public issues. The statements made by Oz express a personal grievance arising out of their personal relationship. They lack any nexus with any issue of public interest, and they do not contribute to any broader public discussion or any social or political issue of public interest. That's debatable. Thus, the Anti-SLAPP statute does not apply. B. Warner. Because the anti-statute does not apply, the court must assess whether the claims against Oz satisfy the Warner Standard. The traditional elements of a defamation claim are 1. A defamatory statement concerning 2. Published to a third party, 3. With fault amounting to at least negligence on the part of the publisher, and 4. Either actionability of the statement irrespective of special damages or the existence of special damages to the plaintiff caused by the publication. Oz contends that Blair must meet the enhanced actual malice standard set out in the New York Times versus Sullivan because the challenge statements relate to a public figure. However, I will not apply the actual malice standard in this posture because the evidence as to whether Blair is a public figure consists for the most part of matters outside of the four corners of the complaint, and I decline to convert the motion into a motion for summary judgment. Thus, for purposes of this motion, I will apply the traditional elements of a defamation claim as set out above. Now this is interesting, because I fully understand why the judge has ruled the way they've ruled. I still think that Blair should accept Oz Media's offer, drop all the claims with prejudice, and move on with your lives. Have a public discussion in a public place. I mean, you're a public figure after all. Surely that's what you want to do, rather than be a image, a symbol for cringe. Oz's challenge focuses first on the first element of the claims, namely whether his statements were defamatory. To determine whether a statement is defamatory, the court employ a two-part test. A court must determine whether the statement contains or implies a verifiable fact about the plaintiff, and second, whether the statement reasonably is susceptible to being understood as an assertion of actual fact. A lot of what Illuminaughti has said in the past is asserted, so this is understandable. Claims 3 and 4 meet this standard. The statements made in both claims contain or imply verifiable facts about Blair, that she committed the crime of embezzlement, and that she placed Oz in a dependent coercive financial relationship. Oz contends, next, that Blair have failed to sufficiently prove special damages in connection with Claim 4, defamation per quote, is that how you pronounce that? Contending that the drop in revenue alleged in that claim occurred before rather than after the contested statement. That is in fact what the complaint alleges. Claim 4 is based on a September 16th, 2023 video, Let's Talk video, but then alleges that Oz's statement caused special damages as evidenced by the fact that Blair's revenue from videos dropped by more than 95%. It did drop a significant amount, and it's called Around and Find Out. It's never going back up to $47,000 a month, I can promise you that. During that same period a year later. Thus, as alleged, that drop in revenue took place in the year before rather than after the Let's Talk video. As a result, Claim 4 fails to plausibly allege the required element of special damages, which tells you she was already in decline, but that decline was brought about by her own poor decisions. Accordingly, I find that Claim 3 satisfies the Warner Standard, but Claim 4 does not. I note finally, the complaint is defectively pleaded in that, yes, it fails to set out each alleged defamatory statement in the form of a separate claim. A number of alleged statements by blank are referenced in the general factual allegations portion of the complaint. Only those that have been separately set out in Claims 3 and 4 will be considered to be claims for defamation. Those that have not been set out in that way will not be treated as such. This is all quite interesting really then, because we now know which claims are going forward and which ones are basically being thrown out. It's a win-lose at the moment for both parties. It can still be argued that Illuminaughti is still actually in the game, although how she is quite frankly miraculous at this point. Ninth claim for relief. Ozmedia objects to plaintiff Blair's ninth claim for relief for computer fraud on the ground that amendment to include this claim was not approved by the court. Defendant responds that the court's order on the 15th of January 2024 authorised a second amended complaint without restricting the claims that it could be alleged in it. I agree the order was not clear as to the scope of the second amended complaint that it authorised. While the order was clearly issued in response to defects in the defamation claims, it did not expressly limit amendment to those claims. I will resolve the issue with an eye to practicalities. No objection has been raised to the ninth claim for relief other than the authorization issue. Were the court to require a motion to amend in order to address this new claim, it would only delay this long-delayed case further. Accordingly, I will treat the order as authorizing all remaining amendments to the complaint, and I will approve the inclusion of the ninth claim for relief in the second amended complaint, but it will be my expectation that the complaint is now in its final evolved form. It is Charizard now. Feels like a Venomoth. Conclusion. For the reasons set above, motion to dismiss is granted in part. Dismissal of the first and fourth claims for relief against defendant Ozmedia is granted. Dismissal of the third and ninth claims for relief is denied. That is Ozmedia's side of things. Of course, when it comes to Felix the KitKat, not much is too different, but we are going to go through that as well. Well, parts of it. Because this is claims of breach of contract. It is not the same legal standard. Before the court is the motion filed by Felix the KitKat seeking dismissal pursuant to that law of plaintiff's breach of contract claims against him in the second amended complaint for failure to state a claim. I previously allowed amendment of the complaint, following which Felix the KitKat renewed his motion to dismiss. I have reviewed the renewed motion, the response and the reply, along with the case file and applicable law. A. Applicable legal standard. When considering a motion to dismiss for failure to state a claim, Colorado courts until recently applied the no set of facts standard. We went through this in Ozmedia's. Under the standard, the Warner standard, the trial court still accepts all allegations in the complaint as true and views them in the light most favourable to the plaintiff, so in favour of Illuminaughti. However, facts pleaded as legal conclusions, i.e. boilerplate or conclusory allegations, are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. B. Analysis. Viewing the amended complaint in the light most favourable to Blair, the court accepts that the portion of the YouTube video referenced in paragraphs 63 to 64 of the complaint is the same as the one displayed via screenshots in paragraphs 116 to 120. It shows Blair instructing her employee, Felix, to help me find Click, a former employee now competing YouTuber, saying the R slur. The word is actually in the brackets there, square brackets, in Sad Milk's raw audio, offering to pay him $200 to find it. Sad Milk is a YouTube channel created and managed by Blair. Again, viewing the amended complaint in the light most favourable to Blair, these allegations arguably state plausible claims for breach of both the NDA and the something agreement. They arguably state a plausible claim for breach of the NDA in that they plausibly allege that Felix, without permission, shared with a third party pyramid information about company operations, as well as information regarding an individual's involvement in pyramid operations. They likewise arguably state a plausible claim for breach of the blank agreement. They allege that, without permission, shared with a third party confidential information for the benefit of a third party. The confidential information disclosed is not, as blank counsel suggests, that Blair uses Arsler in private. That would be a private matter rather than company business. Blank for counsel before would be Felix's counsel. Rather, the potentially actionable conduct by Felix was his disclosure of internal company messages and operations, namely Blair instructing her employee to find potentially damaging information about a competing YouTuber, Click. That information about internal company messages and operations was allegedly disclosed through co-defendant and fellow employee blank to Click for use against Blair. Weren't they Discord messages? If this got through as defamation, it would set a very dangerous precedent for Discord messaging, wouldn't it? While disclosing such tawdry information to a competitor may not be a violation of the Uniform Trade Secrets Act, it could plausibly be a violation of the agreements that Felix signed, as it disclosed to a competitor the internal operations of a company whose business arguably involved trolling for clicks and bringing down its competitors, as the complaint alleges large amounts of money were at stake. Sure, there is an argument about money being at stake on this one. The sharing of private information or messages from Discord being used as defamation fascinates me. It really does. I've never really thought of a Discord server as official business, and yet I use mine for my patrons. And I have mods, although we don't use slurs in private, generally. Conclusion. For the reasons set above, I find that Claim 1 and Claim 2 in Plaintiff's second amended complaint each state a plausible claim for breach of contract against Felix under Warner Standard, and accordingly the motion to dismiss is denied. Which means that yet again Blair is victorious in an aspect. And that is important. She needs a win. She needs to be seen like she's actually getting somewhere with this, especially as, let's face it, she's not going to win the long game on YouTube. She may as well get a victory somewhere. And some people, when they know they're on the losing or on the back foot, they'll resort to, well, this. I don't generally believe that Felix has done much in the way of wrong, and asserting Click as being trolly is quite fascinating to me. Blair was going to get called out eventually by other creators. She really was, and it had been a long time coming. So I'm fascinated to see how this all proceeds, and when Ozmedia's next video comes out. The 7th of June has already come and gone, by the way. His offer extended only to that date.